that the law allows you to limit rights of individuals, okay? But the same law prevents you from arbitrary or high-handed limitation of rights of individuals, okay? And the reason for that is that the Constitution, okay, has an objective, a primary objective of promoting rights. Okay, then the secondary objective is to limit those rights. So the rights come first, the limitation comes second. So in this essence, the right to privacy comes first. Then we can limit that right as a secondary objective if, okay, they need to do so in the public interest. Okay, so the same article, like the way Justin Mlenga explained, is that it provides a tripartite test or a three-part test. Okay, a limitation of a right has to be legal. What does that mean? It has to be provided for by a law. You have to make a law that limits rights of individuals. And this was explained in the case of Speedag Interflight versus Attorney General, where a government entered into a contract limiting, okay, clearing and forwarding companies from doing business in Uganda. And the Constitutional Court says that this particular contract cannot limit rights, okay, because a contract is not a law. That law has to be either a primary law, which is an act of Parliament, or a subsidiary law, which is, like you've seen, a statutory instrument for COVID-19 regulations, a statutory regulation. Okay, and that law has to be public. What does that mean? In Uganda, for it to be public, it has to be gazetted in National Gazette, so that everyone knows that this law exists, so that I can behave in a way, okay, knowing that a law exists that limits my behavior. You can't limit my behavior without me knowing. So there has to be a law that I know of that limits my behavior. Okay, that's the first aspect of legal. Then necessity. The limitation of a right has to be necessary. What does that mean? It has to be able to achieve the objective that you intended to achieve. Okay, and this requires a lot of things. First of all, there has to be evidence. What you're doing is necessary. Okay, there has to be proof. For example, if you're going to track vehicles, is there evidence sure that tracking can limit crime? When registration of SIM cards has a limited crime. So we already have a track record that registering SIM cards has a limited crime, because people have found a way around that. So people are going to still find a way around tracking vehicles. So will that be able to stop crime? Then another thing, a limitation of right has to be rational. Rationality means that it has to make sense. Okay? Why would you surveil someone every single day? Why would you surveil someone's every single movement? I'm going to church, you're surveilling me. How does my going to church relate to national security? I'm going to work, you're surveilling me. How does my going to work relate to national security? I'm going to pick my kids from school, you're surveilling me. How does me picking my kids from school concern national security? I'm going to visit my mother over the weekend, you're surveilling me. How does that relate to national security? Okay? Most of the crimes that have happened in Uganda have been in urban areas. Okay, why are you surveilling the countryside? Why? Why are you surveilling people in Kabale? Why are you surveilling people in Amrat? Why? When all the crimes have happened in Kampala that you're trying to prevent. Why are you surveilling people in Bali? Yeah, it makes sense. So what you're doing has to be rational. Okay, then it has to be evidence-based. There has to be sufficient evidence to show what you're doing is necessary. A very good case is the case of Victoria Ingabire versus Rwanda. In that case, Victoria Ingabire is an opposition leader in Rwanda. So she went to the Genocide Memorial Center, and said that this center doesn't have names of Hutus who died during the genocide. So she was arrested prosecuted and convicted of denying genocide. It's a crime in Rwanda to deny genocide. Just like it's a crime in Israel to deny Holocaust. It's a crime in France to deny the Holocaust. So she was arrested, prosecuted, and then sentenced. So she went to the African Court of Human Rights and said that the crime she was accused for wasn't constitutional. And the court agreed with her on the basis that it wasn't necessary, okay, to prosecute people for saying that you're not recognizing Hutus who died during the genocide. Because both sides died. Okay, and someone is justified to say that, look here, our people died. Okay, how come for them they're not remembered? Okay, and also the court said that that law wasn't necessary because it was suppressing freedom of expression. Okay, anyone who tried to say that, look here, how come Hutus are not celebrated? The Hutus who saved Tutsis in Rwanda, how come those ones are not recognized as heroes? So that was an unjustified, unnecessary limitation of the right to freedom of expression. Then the third aspect is proportionality. Okay, limitation of rights has to be the least intrusive. Least intrusive. Whatever you're doing has to be very minimal. Now, when you go to that tracking system, it has a very big effect on privacy. Okay, and it's not the least intrusive measure because you're doing it 24/7. You're doing it on everyone, and you're doing it forever. Okay, and that proportionality is really provided for in law. That's where I'm going now next. We have the Data Protection and Privacy Act, 2019. It says that you're not supposed to get information from people, okay, that is not necessary to what you want to do. If it's national security, you're not supposed to get information from people that's not related to national security. If it's public health, COVID, you want to expose people who are HIV, who have COVID, so that people can know and not associate with them, right? But you can't expose people's hangouts. You can say people have COVID. These people have COVID. That's okay. You can't say people have COVID and they hang out here. Because where they hang out is not necessary to they are having COVID. Okay? So the law provides for frameworks. The Data Protection Act says that you cannot get information from people illegally. Okay? You're supposed to get information from people following the law. So you can't get information from people illegally. Then you can't get information from people without their consent, except for national security and where the law provides for you to get that information. So if you want to get my birth details, you have to ask for my permission. But for things of national security, you don't need my permission. But you have to do so in a way that is legal. Now, the most appropriate act is the Registration of Communication Act, which we call the RICA of 2010. Okay, it provides proportionality very well because it says that for you to surveil someone, you have to get a court order. Okay, and that court order, to get it, you have to show a judge that that person you're going to surveil has committed a crime or is likely to commit a crime. You're supposed to table evidence to the judge, and the judge goes through it, and according to the judge, it's sound evidence. Then the judge can give you a warrant to surveil someone. That warrant is supposed to last for maximum 3 months. Once those 3 months expire, you're supposed to go back to the judge to renew. Okay, so when you look at all that, this proposal cannot be legal because it's providing for surveilling everyone on their everyday movement indefinitely. So there it can't be legal.